Mr. Lansky, your motion for rehearing, as well as a purge review, Mr. Love was picked up. Well, we were alerted on Wednesday afternoon that he was in custody in Hiilsborough County, so that triggers within 48 hours a purge review because he was in Hiilsborough County. It sounds like he might have been picked up earlier out of state, but we can get into that. But
yeah.
So it's really a purge review as well as your motions for rehearing.
Yes,
so,
Your Honor.
Mr. Lansky, you can proceed.
Yes, Your Honor. My client, Mr. Love. First of all, as you know, I was not his attorney when any of this happened.
Correct.
Or any of this. I practice in Hiilsborough County. I've been practicing for 33 years as a family law attorney, and I am now.
Mr. Rothbard, can you hear him okay from the council table?
It's a little distant, maybe he can come a little closer to the microphone or speak up.
And I am now handling this case and will be in charge.
Is that better? Okay, great.
Yeah. So Mr. Love was picked up June 4th. He's been in custody 16 days in Riverside County, California.
Okay.
We didn't know he was picked up until several days later. Nobody could find him. Then he was transported down here, as the court said, on the date that you were alerted. So he's been in custody about 16 days right now. Your Honor, I've taken over this case. Obviously, you handled the hearing. This was all child support. I'm not sure how it was in front of you because I thought all child support goes to the general magistrate automatically. But obviously you have jurisdiction, so that's not my argument.
Right.
I was just a little puzzled how it wound up in front of a judge instead of, because when it's solely child support, it's always sent to the general master by administrative rules.
Well, I'll indicate there was a GM hearing back in December that I entered an order adopting the general magistrate's report and recommendation. After that, a separate motion for contempt was filed in this division. That triggered the automatic setting of a CMC. Based on that, the clerk automatically sets a CMC when a case is reopened in my division. And so from there, it just went to that CMC that was the one that occurred in April. I think on April 8th, that Mr. Love failed to appear at, so then I did show cause, and that's resulted on the April 21st year.
So Judge, I filed a motion for rehearing. I'm not gonna reread, I'm sure the court has reviewed my motion. I'm sure opposing counsel has reviewed my motion. And we'll talk about the order of indirect civil contempt first, Judge. In that case, my client did fail to appear on April 8th. His contention is he had no communication with his attorney. His attorney didn't show, and he was not advised by his attorney that he needed to be at that hearing. Obviously, the attorney claimed that she was in urgent care. I know it's still his responsibility, but the attorney, his testimony will be the attorney never advised him that he had to be present by Zoom or any other thing. I know that the court then followed up with another hearing, but the indirect civil contempt is based on that missed court hearing, which I believe, since the attorney herself didn't show, there should be some latitude given that Mr. Faizon Love may not have, even though he may have known about the hearing. Most attorneys talk to their clients before the hearing and remind them of the hearing and what's going on and possibly preparing for the hearing. I don't think that should be weighed very heavily. The financial affidavit is the main thing that was pointed out here. And the court refers to dates in the future that opposing counsel brought up that he may be working. And obviously when you fill out a financial affidavit, until those occur, which actually the May 1st through May 3rd in your order of contempt did not happen in Detroit. He did not have those shows. Those were canceled on him. And the May 15th and 16th, they did the shows in Baltimore, but it wouldn't have existed at the time of the financial affidavit. There is an ongoing duty to do a financial affidavit. But my point here is a financial affidavit was filed. I don't believe it's the court's place, unless it's a contempt hearing and unless it's the person is being cross-examined on that financial affidavit, to determine whether it's accurate or not, or whether it's complete or not. If something is missing from mandatory disclosure, like he doesn't give bank statements, he doesn't do any of that, but that's not what was referred to here. What's referred to here and harped on is the financial affidavit. And having practiced law and family law, when a financial affidavit is inadequate or improper or numbers are not correct, that is what you do during cross-examination to show the lack of credibility of the person and to determine whether it's accurate, whether it's truthful, and whether supporting documentation can improve it. It's not for a court to say something wasn't filed. Something can be filed and it can be, and as you know, you've been on the family law bench, financial affidavits 99% of the time are not accurate. Every single person has a deficit, even when they make $500,000, okay? But you attack that on cross-examination. I don't believe it's proper to hold my client in contempt for filing a financial affidavit. As devoid as it was, I don't think the court should hold him in contempt for that. Attorneys assist the clients in preparing financial affidavits, okay? His attorney, in this case, filed the financial affidavit, didn't ask him for any other information, and at the time he filed the financial affidavit, and the testimony should not have been heard at a CMC or an order to show cause. The testimony should be heard at a contempt hearing and challenged by opposing counsel. That is how it is handled. But if he never filed a financial affidavit, Judge, I believe your ruling would have been correct. But in this matter, a financial affidavit was filed. Whether it was accurate or not, I don't believe that the court made the determination or had a full hearing on a contempt where that would have been challenged. So I believe the fact that it was filed, albeit late, Judge, which is that Mr. Love's fault or is that his attorney's fault? That attorney is no longer involved in the case. I'm involved in the case, and I have a financial affidavit because he did work a show in Baltimore, and he gets Screen Actors Guild, SAG it's called, residuals, which are nowhere like the Friends and Seinfeld. He gets about $12,000 to $13,000 a year. I talked to Screen Actors Guild. I got the numbers, but I do not have I still am not in possession, and I've been trying to get the actual printout. So a financial affidavit, as we all know, can be amended at any time. When you go to trial, there's 3, 4, 5 financial affidavits in a file when you go to trial. This will be amended, Judge, but I'm not going to file an incomplete one. I'm going to waiting for the Screen Actors Guild money, which will show about $13,000. He did work a show in Baltimore, and he netted about $15,000, and that will be in the new financial affidavit. So I would ask that you allow me the time to get that additional information so I can file a more accurate financial affidavit. But a financial affidavit was filed. The rule does not say that it must be perfect. It must be, that is what you can challenge. That is what cross-examination is about, and that did not occur at a CMC. And they refer to this May 1st and May 3rd, but the financial affidavit was filed in April, Judge, and the hearing was in April. So how does he include income that hasn't even happened yet? And as we stated, that Detroit show didn't happen. So at the time he filled out his financial affidavit, he wasn't working. This man has no home, he drives a 1999 car, and he lives with his friend who pays all his bills, who's here to testify. He had a movie, and we have a contract of it, but it's right now. It was last week. He got picked up. He can't do the movie. That was going to pay him about $5,000 a week. I have that contract here today. So he has not worked but in 3 minor films since COVID. But the financial affidavit is not what he made in 2022. It's not what he made in 2023. It's not what he made in 2024. It's not even what he made in 2025. It's 2026 income, and at the time he filled out that financial affidavit, he was unemployed, had no movies, and had no gigs. Comedian, he does stand-up comedy too, Judge. And he does colorful stand-up comedy with colorful language, unfortunately. He lets that carry over to his personal life. But, Judge, the issue with that is he did file a financial affidavit. An amended one will be filed. I'm in this case. I have the information. I am waiting for the Screen Actors Guild to verify what I was told over the phone. And my staff has been trying to get that. Mr. Love, I believe, has finally got something to somebody that it has not been sent to me yet, and I'm going to follow up with the name he just gave me. I have had very limited contact with Mr. Love. He does live in California. The court did order him to turn himself in May 1st. Okay? The time for a motion for rehearing was still pending. That order does not become final until the motion for rehearing is heard. So I don't think not turning himself in May 1st should be considered as a penalty or punishment or punitive, because that order becomes final after my motion for rehearing, which was timely filed, is ruled upon. He didn't have money to fly to here and needed the state to fly him here. You know, once he was picked up, he don't have money. He has $100+ in the bank, baby. He has a $500,000 judgment against him every time he opens a bank account plus this judgment, it's garnished. So he has one bank account, Navy Federal Credit Union, with no money in it. Mr. Rodriguez, like I said, is here to testify that he pays for his bills, he pays for everything, he helps him book his shows if he gets them. Obviously, a couple of shows have been canceled in the past because there's a writ of garnishment out there, and every time the shows or the promoters get that thing, they don't want to deal with Mr. Love. They don't want to deal with having to take money and send it somewhere. So those shows get canceled. Like I said, and the movie was Bombshell Betty, that he had a gig for. It was probably a 6-week gig. It was going to be about $4,000, $5,000 a week, which he would have been unable to pay. So on the order of indirect civil contempt, I'm asking that you commute that sentence based on what I've represented here to the 15 days he's already served, or in the alternative, suspend the remaining of the sentence pending my submission, waiting on the Screen Actors Guild only to be able to submit that financial affidavit. And I do have a draft of a financial affidavit, but because of the court's ruling, I would like to have that Screen Actors Guild backup so it's not accused of being inaccurate. But I do believe the proper forum to challenge a financial affidavit's accuracy is not at a CMC. It's not at anything but the motion for contempt hearing, Judge. That's when you challenge it. And if he's able to challenge it and say, Mr. Love, didn't you work this show? And Mr. Love, didn't you work this movie? And then it shows that he didn't include it, well, guess what? His credibility is shot. That judge is going to order him to pay what she believes his true income is. And his credibility is determined by the judge because he swore under oath that this affidavit was true and correct. But that's the form to do it in. I don't believe indirect civil contempt for that is proper. I would have my client testify once I finish my argument about not being notified by his attorney that his presence was needed at that hearing. Moving on to the criminal contempt, Judge. I was not present.
Can you press one thing at a time?
That's up to the judge.
There's a lot of arguments made.
Yeah, that's
there.
fine. We can address individually. Response, I guess argument, Mr. Rupp, response on that? Just on the indirect civil.
Yes, absolutely. Judge, I know this attorney was not the attorney on the case at the time, but he apparently is not aware of what was really going on. First of all, in the several years since the final judgment hearing, since the 2019 case, Mr. Love has not paid a penny in child support. There's several $100,000 of monies owed pursuant to the final judgment hearing, which I think was entered in 2023. He has literally not paid a penny. The only money in child support that my client's gotten has been pursuant to writs of garnishment, seizure of assets, things like that. Not a penny's been paid, and that matter's been pending before the GM. There's a contempt pending against him there. That's not before Your Honor today. But what is before Your Honor regarding this matter is not only the failure to provide the financial affidavit, but if you look at the order of indirect civil contempt, it's not just a financial affidavit. It's Mr. Love may purge himself of the indirect civil contempt hearing by providing a full and complete family law financial affidavit, including all attachments thereto required by 12.285E, which is the mandatory disclosure, which is not only the financial affidavit, but the bank statements, the credit card statements, the credit applications, the tax returns. Not a single page of documentation of that has been provided. Mr.
Mr. Lansky.
Lansky, I'm sorry, has advised that, he said, and I quoted this, as devoid as it was, referring to the financial affidavit that's been provided. The financial affidavit literally said, 0 income, 0 assets, no bank accounts, no nothing. It was not like missing a few things. It was not, it was literally just a blank financial affidavit, essentially, saying, I have no income. We have collected, as I mentioned, some money pursuant to garnishments. And these garnishments are not small amounts. Yes, there are some small amounts from certain locations that we get. But just from a single comedy show that he did, which we had to litigate before the general magistrate to actually get paid, because Mr. Love's, one of his prior attorneys, was threatening the comedy club that they would sue them if they gave me any money pursuant to the order, which the GM ended up saying, you need to give that money, was over $9,000. So that was just about half of what he earned. So he's earning about $20,000 per comedy show. He does several shows in a weekend. He flies to different cities and does a comedy show and headlines and they advertise it. And we've been sending out letters to these comedy shows saying, hey, he's performing there in 3 weeks. Here's a copy of the court order seizing, 55% of his income. And they end up fighting us on it. And like I said, you can take a look at the court record and you can see where that is. So it's not just a matter of, oh, well, I was between jobs. He gets constant money from his prior shows and movies and things like that. He's constantly doing comedy shows all over the country where he flies there and does these comedy shows for $18,000, $20,000 a pop. And to say, well, but I had a comedy show and it canceled, so I put zero income, is not, well, but that's how it's done. I mean, if you're a plumber and you plumb one day and you plumb 3 days later, but you do a financial affidavit in between those days, on your day off, you don't say, I make zero income. I mean, that's just not how it works. So it's not just the matter of a financial affidavit that he has provided. It's a bad financial affidavit. It's an incomplete. It says specifically in your order, a full and complete family law and financial affidavit. And the second matter is the documents, the tax returns, the bank statements, the credit card statements. None of that's been provided. We're not required to take his word for it that, oh, well, I'm here in court today and, I'm going to say that I don't make any income and I don't have any money and I just get these small little checks and this movie is now canceled. We're not required to take his word for that. We're required to actually see the documentation. He's required to comply with the law. There was a specific purge put in that order that he has to provide a full and complete financial affidavit and all the documents pursuant to 12.285E. He hasn't done either one of those. His own lawyer said that the one he provided was as devoid as it was. So it's not been there. Now, if he does provide those things, the order specifically states, should the documents be provided to Mr. Rothbard? And should the parties agree that said documents are complete, the parties may submit an agreed order discharging this indirect civil contempt. But if documents are provided and Mr. Rothbard does not agree that the same are complete, a hearing may be requested by Mr. Love where the court will determine whether his obligations here under the next bill. That's not part of this motion for rehearing. He wants to do that and say, well, but we provided everything and we're going to provide everything and there's nothing to provide, but that's not set for today. It's not before the court. He hasn't filed the motion. He hasn't provided the documents to even be in a position to file the motion. So any motion discharging the indirect civil contempt it's not appropriate. The matter was properly heard. He failed to comply with the court order. A motion for contempt was filed. We had a hearing on it, and the court made a ruling on the hearing about it. Again, he said, well, it was just done at a CMC, but it wasn't. There was actually several hearings before that where these matters were addressed, which culminated in the CMC. But again, there's a specific purge. He hasn't complied with that purge, and here we are. He still hasn't paid a penny of child support. And I need to add, obviously, that the court said, turn yourself in by May 1st. He didn't do that. In fact, at the hearing, if you look at the order, he said, I'm in California, no one's going to find me there. He was picked up in California at an Indian casino. And that's where he was picked up. It wasn't like he turned himself in. It wasn't like he did the right thing. And he's had, by the way, he's had 3 lawyers since this happened. He's paying lawyers, 3 of them. Mr. Lesky is the 3rd one, and still not paying a penny in child support. I actually have a motion pending to sanction him for that and compel his compliance because he hadn't turned
Your Honor, I'm going to object to any reference to a motion that's not noticed for today.
Hold on, Mr. Rothbard, there's an objection by Mr. Lansky.
My objection is what's noticed for today is what's noticed for today. I don't care what motions he's filed. That's not on the,
Yeah, you don't need to go into whatever motions have been filed or have yet to be, that aren't noticed for today.
But the fact is, Judge, that he hasn't complied with the court orders. He was at the hearing where the court said, turn yourself in by May 1st. There was no question about this. And he didn't do it. Just like he said he wouldn't do it at the hearing. He said, no one's going to find me, no one's going to pick me up. Well, he was wrong on that, right? But the fact is that he hasn't provided the discovery. He didn't comply with the original order of the court. It was a contempt hearing. That contempt hearing was finally heard. He didn't provide a financial affidavit. He's admitted he still hasn't provided a valid financial affidavit. He hasn't provided any of the 12.285E documents. There's no question about that. His lawyer's not even arguing that he's provided these documents. So he hasn't done what he needed to do. And that is not a matter for a rehearing. Even if he had, that would be a matter for a motion to discharge the contempt pursuant to the order.
Well, what's your position on the hearing from which the indirect civil contempt order came about? Was Mr. Lansky's argument is that's not the appropriate, he filed a financial affidavit 30 minutes before that hearing, and that hearing was not the appropriate forum to probe the validity or accuracy of that financial affidavit. And a finding of contempt based on a facially, suspicious financial affidavit is not was not an appropriate indirect civil contempt finding. Because he did file it, and the veracity of it is best left to a hearing regarding that issue.
So Judge, the fact that it was filed, first of all, in the rules, there's, I want to say it's 12.2 something, but I can't remember exactly. If a document is provided less than 24 hours before a hearing, it should not be considered by the court. That is one of the issues. The second issue, Judge, is he still hasn't provided, and that was on April 21st was the hearing. April 21st was the day of the actual contempt hearing. The financial affidavit was supposed to have been provided substantially before then. But separate and apart from that matter, and I want to say for some reason that the financial affidavit wasn't provided until after the hearing. I could be wrong on that, but I think it was provided after. I think there was a notice filed, but the actual affidavit wasn't filed until after.
No, we had the financial affidavit prior to the hearing on April 21st. It was filed on April 21st in the morning at 8:08 a.m. And it was referenced. You had it. You started to make argument on it at that hearing about it showed zeros, and so that we were certainly addressing that.
So again, the fact that it was ordered prior to that, it wasn't like it was ordered to be provided that day. It was ordered in a, I can look at the indirect civil contempt, but it was an order to show, there was an order to show cause on April 10th, which was issued. And there was an order prior to that, the case management conference, dated January 29th, where he was ordered to provide this document, and he never did. So it wasn't just on that day he didn't have it, it was ordered several months prior. And literally not even on the eve of the hearing, but apparently a half hour before the hearing was when it was finally provided. And again, not a single 12.285E document, not a single tax return, not a single bank statement, nothing. And those matters were specifically addressed in the indirect civil contempt order in the purge. So if he's disputing what the purge is, that's not a rehearing, which is what his motion is. His motion is saying somehow there's a problem with the order. He's not saying, well, he's complied with the purge, we should release him on the indirect civil. That's not before the court,
Well, it is. It's a purge review. I certainly have discretion to basically change the purge at any time. He's been picked up on a warrant or on a writ of bodily attachment on an indirect civil contempt. This is now a purge review. I have discretion to modify the purge, even absent a motion for rehearing.
Yes, but we're still missing, like I said, a valid, full and complete financial affidavit, and that was what was in the order, not just any financial affidavit that says zero, but a full and complete one.
Right, I got it.
And the second thing is all the documents supporting it. Again, we're not just required to take his word for it in his statement or in his financial affidavit. If you look at the final judgment in this case, Judge, and I know it wasn't you, it was a prior judge, but he said, look, Mr. Love is lying. He says that he doesn't make any income, but he had $500,000 worth of deposits in his account for the last several years. So, this is not someone who's credible. We should just take his word for it. He doesn't work for the state of Florida where he gets a W-2 and that's it. He gets money from different sources. He gets money from comedy shows and things like that. So we shouldn't have to take his word for it, whether his spoken word or his financial affidavit. We're entitled to see the documents, the bank statements, to see if they actually have $100 in them, to see if there's actually money coming into them, to see where he's paying his expenses, to see where he's getting his money to fly to all these places and do these comedy shows. We know he's been getting thousands of dollars because I get checks. I've got thousands of dollars of checks from the writs of garnishment that I issued to various places, including several from comedy shows, which are in the nature of $8,000, $9,000, $10,000, because that's what he gets paid is twice that. So again, I don't think that he has met the purge. I don't think the purge should be changed. I think there's a valid purge here with regard to not just a valid financial affidavit, but also the supporting documents. Like I said, the actual contempt for the non-payment of child support is not before you, but the contempt for not complying with the court's order from January is before you, and you did order those things to be provided, and they were never provided.
Your Honor, may I respond?
You can.
So Judge, when things like this happen in family law, there's something called notice of production from non-parties, subpoenas, which Mr. esteemed counsel on the other side has never issued. There's also something called a deposition, which esteemed counsel on the other side has never done. If he thinks he's lying, these are things that you can do. These are things that are in our family law system, depositions and non-production parties. If he talks about all these comedy shows, there was no comedy shows in 2025, and there's been one in 2026. The $500,000 deposit, the last time he had $500,000 in the bank was before this child was even born. And I think it's disingenuous to say nothing's been paid, because since, regardless of how it was gotten, since 4/26 of 22, $43,000 was garnished. And there's, by the way, there's no $9,000 checks anywhere on this. There's no checks. One check of $16,000, every other check is $5,000 or less. So, oh, I'm sorry, Judge. These aren't garnishments. I want to point out, and I'll show the court, the document, which are direct payments of $43,000 since 2022. So for counsel on the other side, and I'll pass this to the court. For counsel on the
direct payments from whom?
These are direct payments from Mr. Love since 2022 in the amount of $43,000. So for him to argue at a hearing that zero's been paid, which upset my client immensely, because counsel on the other side was obviously misleading this court, because the document's right there. Those were direct payments to the child support since 2022, the last one made in March of 26. So for him to come into court and argue over and over in front of my client, and like he did today, that he's paid zero, is an absolute falsehood.
Judge, I don't know what he's showing you, but...
I'm showing him a court document where child support's been paid.
Hold, let's not talk over each other. It's a,
he hasn't made a single payment since the entry of the final judgment, which I believe was in 2023.
Okay.
So
Please look at that document to show that counsel on the other side is lying.
That's not what I mentioned, and that's not what I said. I specifically said since the entry of the final judgment. I have no idea what payment he's talking about in March. I would certainly like to see it, but
he has gone over and over and said zero, zero, zero.
all right, hold on. We're talking over each other, so let's not do that. Yeah, it's a Florida clerk of court, CCIS, child support inquiry details.
And I've added that up to
I don't know where did this come from, Mr. Lansky?
from the court. That's a court document that we printed out.
I have no idea what he's looking at.
Well,
There was a hearing in front of the magistrate. The magistrate found he had not made anything in December of 2025. Magistrate.
I don't know what it. Yeah, I understand.
Found that there was no payments that had been made.
Judge, I don't know what his previous counsel did, but I'm counsel now. That is a court document. That is from the clerk's office, showing payments made with the account numbers. And this gentleman has represented this court and accused my client over and over in court when he got very upset of $0 being paid. I don't even know how much was paid in garnishment, but that's $43,000 over a 3-year period.
You pulled this yourself from the court from the clerk's office?
My staff did. I don't think it's something you can create, Judge.
No,
The second amended final judgment was entered in September of 2023.
Okay.
I don't have any payments since then from Mr.
That's not what the document shows.
Document showing.
The
I don't know if he's showing
payments, there's payments reflected of $2,000 payments.
What about the 16.5, Judge?
That was in July of '23.
And when did
I'm
he
talking
say
about post that September of 2023. 16.5 in July of 2023. And then,
No, the final judgment was entered on September 18th, 2023.
No, he said the amended final
Anything else
judgment.
after that? Because I don't think there were.
after that, this document that I'm looking at reflects payments on March 3rd of $1,000, another March 3rd of $1,000. Although actually, no, I can't. Well, one says 1,000, one says 11 cents, so I don't know what that means. And then on March 5th, $1,000.
Of 2026?
2026 in March.
I'm unaware of those. I see my client raised her hand.
Ms. Lee, did you receive those payments?
Yes, I did, Your Honor.
Those are $3,000 payments?
It was actually $1,000, and then there was a separate payment of 11 cents, and then another payment of $1,000, and that was back in March of 2026.
Okay.
That is correct. Yes.
So I apologize, Judge. In the 3 years since the entry of the final judgment, you've made $2,000 worth of payments and 11 cents.
All right, but then, and there's reflected payments prior to that on this sheet from July 2023 and earlier.
Right, and that totaled
I'm not
43,000, not
disputing that you
including
made
the
some payments prior to the entry of the final judgment. My statement was subsequent to the entry of the final judgment.
Okay, so the payments were made in March of 26. So at the time of the hearing in front of Magistrate Sarmiento, there was, I mean, it was accurate. Had not been payments made since the amended final judgment.
I'm just saying he went over and over and said 0, 0, 0.
I got it. There's three payments, looks like, or two payments made in March that were that are
Well,
that are accounted for.
I believe was the final judgment. All right, Judge.
So Mr. Lansky, what's the relief that you're asking for in the indirect civil contempt?
My relief is that it should not have been granted at the hearing you had.
Right.
It wasn't a contempt hearing. It was an order to show cause hearing, okay? And he was not noticed of anything else than that. There wasn't a motion to hold him into indirect civil contempt that I believe. I wasn't there, but looking at the
There
document.
was no motion. It was an order to show cause, to come in and show cause as to why he failed to appear at the April 8th hearing
Correct.
and failed to file a financial affidavit.
Okay.
And,
But there wasn't a
and
motion.
if you fail to show cause, you could be held face a sanction, including incarceration. That was within the order to show cause.
Yes, Your Honor. And I'm saying that he did file something. And it's not your job to determine whether, at that kind of hearing,
Right,
it's
I
not
get the
your
argument.
job to
What-
determine whether it's accurate or not.
What's your relief that you're asking
My
for?
relief is that the indirect civil contempt should not have been entered, because he did turn in a financial affidavit. I don't see any good faith letter on 12.2285 in the file anywhere. I don't think it was right to be heard. And how do you produce something that has zero? If there's no bank accounts and there's no, he keeps talking about these jobs. He says he's got a bank account, he's got this. Well, if he doesn't have any documents, how does he know that? He's making stuff up as he goes along, Judge. There were no comedy shows in 2025, zero. There's one show post-filing of the financial affidavit. So at the time the financial affidavit was filed, his income was zero. There were no comedy shows in 25. So you can't sit here as a reviewer of fact when that wasn't what the hearing was about. I was told or informed the financial affidavit wasn't even gone through. There was no inquiry whether it was accurate or not.
There was an attempt at an inquiry, and that's when things went off the rails.
Okay, well, I understand, but an inquiry was not done. Okay, so this is premature.
Well,
And
there-
the order is not final
All
until
right,
my motion for rehearing is run, so there is no order in place that would require him to power of attorney out there. I can't get record, I can't call his bank, I can subpoena the records just like counsel could, but Judge, my point of view is there was no violation at that time, okay? I don't know this, I understand the court went awry, but you'd have to finish that inquiry, Judge, before you can file an indirect civil contempt. The criminal contempt, something different. But the indirect civil contempt, you by your own nature said there was an attempt at an inquiry, but no inquiry was completed. So this is premature.
Well, there was an inquiry,
There was an attempt, you just said.
and it stopped very quickly into that inquiry because of
Okay.
the criminal contempt. So
Did the court reconvene a hearing at a later date to have that inquiry completed? It did not.
So why don't you address the direct criminal contempt?
Okay, well, my other relief would be suspend the remainder of the sentence. Allow me a sufficient time as the new attorney to file the affidavit and get whatever records exist. He can't say you owe this, this, and this if they don't exist, okay? I can't produce what doesn't exist. That's why we have notice of production from non-party and depositions, which neither has he tried to do. Neither. So he's sitting here saying it's all wrong, but he's done nothing to confirm it. He just says it's a lie, it's a lie, it's a lie. That has not been determined by any court that it's a lie. Maybe it is, maybe it's not, but it has not been determined by your court or the GM's court in any way whatsoever. So at this point in time, you have a financial affidavit. And the documents that need to be produced, I'm on the case, and I want to be given ample time to work with my client to get those. Obviously, living in California, that's a difficult thing. And I have testimony here, if you want to do the inquiry, that he has no home, everything is paid for by his friend Robert Rodriguez, and he has no money, and he drives a 1999 car. And he has no assets, and he's got a $500,000 judgment out there that can also garnish, and it's probably in front of Mr. Robarts, because it was first in time. Okay, the criminal contempt judge, procedurally, his attorney was not a criminal attorney, judge, and he should have been afforded the opportunity to get new counsel to handle the criminal contempt. His attorney had no experience in criminal law, as far as I know, and it went directly into that. Normally, when I see criminal contempt, a hearing is set, and he's given ample time to get a proper attorney. I don't see that anywhere in the order. Again, I wasn't at the hearing, judge, but that criminal contempt should have been with a criminal attorney because it dealt with incarceration, and it should have followed proper procedure, not gone immediately into the hearing. I understand that they didn't present any mitigating circumstances. I'm not sure his attorney knew that he was entitled to have a criminal experienced attorney handle that case. So I don't think he should be punished for that, judge. I would argue, I'm not excusing his behavior. I wasn't here, but from what was written in the agreement, judge, what was written in your order, no, he should not act that way. He was frustrated at that hearing because he thought that Mr. Robarts was representing things that were inaccurate, and he lost his cool. He's also, with the criminal contempt, he has extremely high blood pressure. He's obviously in a wheelchair. He is AFib, and he has medical conditions. He's obviously very overweight. Excuse me, sorry about that. He has medical conditions that can't be properly addressed in the jail, judge, and I'm going to be filing a supplemental petition to modify the child support amount based on what his current circumstances are. But what an updated financial outlook will show is he makes about $14,000 a year off of Screen Actors Guild. Since streaming took over, the only people that make money are the actors of Friends and Seinfeld because those are still on regular TV. He does not have money. They think there's deep pockets. They think there's deep money. They think there's hidden money. Well, they haven't done anything to show that either. I can't produce documents that don't exist. If he doesn't have this and he doesn't have this, they don't exist. Are there some documents that need to be produced? Yes, and I'm asking the court time to do that. But on the criminal contempt, I think the punishment was, obviously, this has been very contested. It's been very, draining on Mr. Love. He hasn't been able to work. He doesn't have a home. He doesn't have any money. He relies on friends to help him out. And he was wrong, Judge. He shouldn't have talked to anybody like that, especially a judge. I know that you said you tried to mute him. My understanding of the system, and I've been in a lot of hearings, is he could have been kept on mute. You can't unmute yourself if the judge mutes you. If you unmute somebody, you cannot unmute yourself.
You can't.
You can. I've never been able to do it on the hearings. If you unmute him from your system, I'm unaware of anything that you can unmute yourself.
Well, you can, and he did. So
Okay, I understand. I wasn't present at the hearing, but my experience is I've never been able to do that. So, Judge, it was wrong, but 90 days is punitive, over the top, and this is a child support case. If he can't work, he can't pay. I understand they say he can't do that, but he had a movie. I had the contract, signed contract, for Bombshell Betty, which he would have been working right now. So, we can keep him in jail, and what's that gonna solve? I can't get the documents from him. I can't do anything. I am new to the case. I'm asking you to give me some leeway as an officer of the court to get what needs to get done, and then also require Mr. Robarts to do what is available to him to verify that what we're saying is BS. okay? Because there are things he can do. He chose not to do any of that and just wants him thrown in jail. Well, I don't know how throwing him in jail and keeping him in there for 180 days helps Miss Tiffany at all, because obviously he's not doing any comedy shows, and the longer he stays in jail, the less Hollywood's gonna deal with him, the less comedy clubs are gonna deal with him, the less anybody's gonna deal with him. So if the real thing here is to help Miss Lee, it's not met by throwing him in jail and ruining any possibility he has to work in the future, because there was a job, and he can testify to that. And then I'd ask, that's my argument, that it's too punitive, that 15 days, a little bit more, if the court feels fit, is proper. That 90 days is punitive for the behavior. Not here to excuse it. Not here to justify it, other than him being emotional, and he's emotional with me. He's a very excitable guy, and he has his positions, and albeit how wrong they were, Judge, I think that the 90 days is over the top. And just so the court knows, I can file a motion to modify. I'm still within my time, or mitigate if the court doesn't want to address this today, because I have 60 days from the date of the final hearing, which would be June 28th. But I ask the court address both my motions and either give me a rehearing on the indirect civil contempt, or give me a rehearing on the criminal contempt. As a criminal attorney of 30 years, let me represent him with the expertise I have in a criminal contempt proceeding, not someone that has no experience doing it, and waived his right, because he absolutely would have had the right to have a hearing in the future with an attorney of his choosing. Thank you.
All right, I'll hear argument from Mr. Rothbard on that, and then if you indicated you wanted to call your
I
client.
would like to call Robert Rodriguez first, yes, because they're claiming all this stuff that he has and money he has, and he can testify that who pays his bills and who does everything.
All right, that's fine. You can, he's still on Zoom. You can call him in a moment. I'll let Mr. Rothbard respond on argument regarding that. If you indicated you wanted
Yes.
to have call your client as well, so.
My client briefly, yes.
We can do that. Mr. Rothbard?
So Judge, in response, the attorney says that I, should have issued, notice to produce the non-parties and things like that. I don't know who to issue them to, Judge, because he hasn't provided a valid financial affidavit. Even the one he provided on April 21st, if you look at it, he says he has $167 cash in banks, credit unions, etc. It doesn't say which bank it is. He doesn't say it's Navy Federal or any other bank. He just says, in a bank, somewhere in the universe, there's a bank with $167. I'm not going to tell you which one it is. I'm just going to tell you it's in a bank. So suggesting that we can figure this information out on our own is not really valid. But going back to the criminal contempt, Judge, and again, I know the attorney wasn't there for this hearing, but the order, which of course I wrote, was pretty specific about what actually occurred. And this was not a one-time, expletive to the court. This was numerous expletives over and over again, with numerous warnings by the court saying, Mr. Love, please be quiet. Mr. Love, please stop that. Mr. Love, please stop cursing and yelling. You silenced him several times. You muted him, and he unmuted himself and kept going, even after warnings that he would be held in contempt if it continued. And it did continue. And to add insult to injury, Judge, Mr. Love, I believe, is on diversion in California out of San Diego on a criminal case right now for throwing a credit card machine.
Objection, relevance,
at a
Judge.
hotel clerk.
Yeah, I don't.
Objection, relevance, it's not a conviction, and there's no reason that he should bring that up other than to inflame the court.
Yeah,
and give them information that's inadmissible.
I'll sustain.
So, as it says in the order of Mr. Almost immediately at the outset of the hearing, Mr. Love began acting inappropriately, constantly interrupting, raising his voice, and even began using profanity. He was muted several times by the court, but continued to unmute himself. He was warned several times by the court to stop yelling and using profanity, but continued. Mr. Love was specifically advised that if his inappropriate behavior continued, that he would be held in contempt of court. Even his own lawyer told him to stop, but he refused to listen. As the hearing proceeded, Mr. Love's behavior worsened, calling the court cracker, motherfucker, you fucking idiot, and white boy, among other expletives. He also yelled fuck you to the court several times and was bragging that the court could not take him into custody because he was in California and no one would find him. That's what happened, Judge. I don't know if anything, argument can change that. The court entered the sentence. It was a valid sentence. It was half of what the court could have entered. The court could have entered a 180-day sentence. But that's what he did, and it was not a one-time thing. It was after numerous incidents. And this wasn't the first time that Mr. Lucky in this particular litigation has cursed out a judge. He cursed out the prior judge.
Objection, Judge, that is not before the court
and
and should not be considered because there's no order of contempt or anything that another judge did. And no offense, I'm not taking Mr. Robart's word for it.
I was at the hearing.
Well,
I don't care.
I mean, that's not really
Hearsay then.
That's not relevant to, it's not hearsay, but,
What the
or
judge
it's
said.
hearsay if there's an exception, but, no, I'll sustain the objection. That's really not the reason I held him in contempt, so.
Sure, but the point is, Judge, is that this wasn't just a one expletive, you're in contempt. This was an ongoing, a man who just didn't want to take your answer and didn't want to answer your questions and didn't want to deal with the case and thought that lashing out at the court and trying to intimidate the court would be his way of getting out of the situation. And clearly it didn't work out very well for him. But 90 days on this type of behavior with multiple expletives, yelling, screaming, cursing, racial expletives, cracker, white boy, things like that to the court in the middle of a hearing is just inappropriate, especially in light of everything else that's going on here.
All right.
And also, Judge, let me ask you just one thing. A motion for a hearing doesn't toll a court's order. It doesn't automatically stay. If the court says, I'm sentencing you to jail, it doesn't say, well, but I asked for a rehearing. You have to go to court and say, well, I'd like a supersedious bond. I would like a bond to address this matter while I am disputing or appealing or asking for a rehearing. You don't just say, well, I guess you filed a motion for a rehearing. We can't sentence you. We can't send you into custody. That's not how it works. It doesn't automatically suspend and cancel and do anything to an order, especially one like this. So him saying, oh, well, I didn't turn myself in because I was waiting to hear what happened on the motion, it doesn't excuse his failure to comply with the court order of turning himself in.
And Judge, at no time did I excuse his behavior or diminish it. I just said that the penalty was too much.
No, I said at no time does it excuse his failure to turn himself in pursuant to
No,
the
that's
court.
not what I'm referencing. I'm just referencing.
Right.
I just want to make it clear to the court. I am not excusing his behavior. It was inappropriate. Okay, but there were words. He didn't punch out a bailiff. He didn't do things. He showed disrespect to this court. And I'm on the case now. That's not going to happen again. And the bottom line is, Judge, I just think 90 days is punitive. It's too much. All right, you proved your point. He lost a movie. He was picked up in California and sat in Riverside County. He was flown here. Now he's sitting in the jail here in bad health. As the court knows, he's in a wheelchair. He's in red. Is he going through a lot? Being broke, destitute, after having a life where he was an actor, doing very well? It's just not there anymore. So for him, he says he doesn't know about places. He, in reference to the court, that he did these comedy shows and he made this much money and he did this. If he did all these comedy shows, he knows where he did them. He's just making that up because they didn't occur. But if he knew about the comedy shows, he can obviously subpoena the records. He can obviously, what he didn't address is deposition. Ask him the questions under oath and ask him where his bank account is and ask him how much money he's got and ask him all these questions. He chose not to do that. Instead, he just wants him in jail, which does not serve his client in the least. A movie for the next 6 weeks would have gotten his client another $10,000 or more because he could have garnished half his wages. But instead, he chooses that he wants him in jail. And that does not serve his client or society or the child at all.
All right, you want to do,
I'm going to call Mr. Robert Rodriguez to just verify.
Mr. Rodriguez first? All right.
Can I just add one thing? He keeps saying that I didn't subpoena people, I did, but that's the whole purpose of a mandatory disclosure. It's the whole purpose of a financial affidavit is to say, these are my bank accounts, these are my assets, this is my income. We shouldn't have to go out and search and try to locate these things. He's been actively avoiding, as I mentioned, in the GM's hearing, he had a comedy show in Washington, and this, he threatened the comedy show and said, if you pay the child support pursuant to this order, I'm gonna sue you. And we actually had to have a hearing where the general magistrate ordered, basically overruled that and said, no, it needs to be paid. This is inappropriate.
Whole purpose of a deposition, Judge.
So this isn't a matter of, oh, well, he should have issued, garnishments to these places. We did. Everywhere that we could find, we issued garnishments. But because he doesn't provide the information, which he's supposed to, that 12.285 in the financial affidavit is the basis, it's the crux of the discovery from where all other discovery flows. He said, well, I didn't provide that, you should have figured all that stuff out on your own. And that's one of the reasons the attorney's fees on this case are so high.
And I see he didn't address the fact that he didn't take a deposition, which would have
All right.
covered everything.
That's we're getting off track here a little bit. I'll admit, Mr. Rodriguez, you want to have some brief testimony from
Yes,
him?
Your Honor.
And then also your client indicated.
Yes, Your Honor.
Just one other thing is, I'm going to object. I don't know what Mr. Rodriguez's purpose in testifying here is. It's not really relevant to the contempt.
This isn't a contempt hearing, Judge. It's a motion for rehearing, and he's claiming that he has all these documents and that he has all this money that he's not disclosing. Mr. Rodriguez can put an end to that, because that's the guy that supports him.
Well,
that's the guy that pays every one of his bills.
The witness is the witness
Well,
is.
hearsay, Judge.
What's that?
Any information about Mr. Love's finances, his personal finances, would be hearsay of things told to him by Mr. Love.
The guy lives with him and pays all his bills. How's that hearsay?
Financial documents.
How's that hearsay if he pays all his bills? That's what he's going to testify to, that he lives for free with this man, that he pays all his bills, and that he doesn't have, and he's never had any money to contribute. That's what this man's going to testify to. I can proffer it if you don't think it's relevant, Judge, but that's what he's going to testify to. He's making a big deal that all this money exists, that we're hiding it. This man can dispel that, as well as any other form of discovery.
Documentation of this. We're not just required to say, oh, by the way, here's this guy, Mr. Rodriguez, and
He opened the door, Judge.
Well, it's real. He's calling that witness with respect to the validity of the financial affidavit that was filed shortly before the contempt or before the show cause hearing that this court found was not a credible affidavit, and I think it's a witness to that's related to that issue. I'm not sure why you're calling Mr. Rodriguez rather than your client with respect to his financial affidavit.
My client can't testify that all his bills are paid, but this man can testify he pays all his bills. That Mr. Love does not pay rent. That Mr. Love doesn't have income coming in. This man also does the comedy shows with him. He's his opening act for the comedy shows. He's the one that books it. He can also dispel everything that Mr. Robarts represented, that he did all these comedy shows in 2025 and had all this income. There were no shows in 2025, Judge.
But these are things that should be provided with documentation. If Mr. Love is claiming that Mr. Rodriguez pays all his bills, he should provide the bank statements from Mr. Rodriguez showing his bills are paid by him. He should provide his cell phone bills or his credit card bills or whatever it is showing his expenses are paid by him. Having someone come into a hearing, again, on the 11th hour, kind of like, he provided that financial affidavit a half hour before the hearing.
I did not do anything.
I have this witness that is going to say, I pay all his bills and that's why he doesn't have any money. This is the whole purpose of discovery. He can't just come in and say, oh yeah, I pay all his bills. We're entitled to the documents. We're entitled to say.
I don't think Mr. Lansky's arguing that you're not entitled to documents as a result of that.
I'm asking for time to get that.
Or that this witness is going to.
What he's saying is that we have to take Mr. Rodriguez's word for it, that this is what's going on, without any documents, is what he's saying.
Mr. Rodriguez's documents aren't relevant, Judge. He's going to testify to me, and I'll proffer the testimony, Judge. You can't dispute it.
You've already proffered the testimony.
If you don't need to hear from him, that's fine.
If you want to have your client provide some testimony regarding, really, the issues are the validity of the financial affidavit and whether there was, that was in good faith or credible.
That's one of the issues, Judge.
On the indirect civil contempt, and then with respect to the criminal contempt being excessive.
Yeah, okay.
So, you proffered about what happened in the criminal contempt.
Fine.
If you want to call your client?
Yeah, I'll call Mr. Love.
Mr. Love, you can raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you.
Mr. Love, when you filled out that financial affidavit, did you provide all the information to your attorney
Yeah.
that you had?
Yes.
That you had available to you? Had you worked any shows at that point in time in the last year and a half?
No.
No shows at all in 2025.
There was one show
Well, I'm sorry, let's talk about 2026, because that's when you did the financial affidavit. In April of 2026, April 21st, you filed a financial affidavit, you signed.
right.
At that point in time, did you have any income from movies or comedy shows?
No.
Okay. So at the time, in April, you had zero income?
0.
Okay. And you do get some money from Screen Actors Guild periodically, right?
It's
I'm
very
just gonna object to leading, this whole series of questioning has been leading.
$13.
That's leading, but
Okay. What is Screen Actors Guild?
Our union,
And do you get paid by Screen Actors Guild?
they send out checks randomly.
How much was last month's check?
7 cents.
Okay. During Christmas, you get more?
It's not Christmas, it's January. You're talking about for Elf.
Yes.
And
But
that,
I'm sorry, I'm having trouble hearing and
maybe,
understanding, Mr.
maybe
Love.
move that mic closer to him, yeah.
January we'll see as a quarter for December, and that sometimes would include a Elf check. Well, that's what you're saying, and that's like maybe 10 grand, maybe.
Can you tell this court why yourself as an actor and other actors are upset with the Screen Actors Guild?
Well, there was two.
Action relevance.
He's gonna show why there's no money coming in, and he's gonna testify that
Well,
they
You can't
because
testify
it's
about
training
what,
services.
what other actors feel about
Okay.
SAG, so.
Him, no, about SAG. Tell the court why you don't get money from SAG like it was in the past.
Well, we've been striking since COVID. It was 3 strikes. So, and one of them was about how they pay us in ancillary markets from Netflix, and Netflix doesn't pay what the other market pay, so it's very diminished. So for HBO movie, if you may receive a check for $58,000, but that's no longer because most everything is what they call streaming.
And that's since COVID?
Yes.
Okay, and what is the most money you've made? This case was in 2023. They said a final judgment was entered in September 23. So 24, 25, and 26, how much was the most money you made in any of those years?
23 was maybe 19,000.
Okay. 24?
24 was 24.
If you recall.
I'm trying to remember. I saw I think it was 16,000.
Okay.
That was residuals.
And when was the last comedy show you did?
The 26th, 27th, 28th of what month are we in right now?
We're in June.
Right before June, May.
So May?
Yeah,
So you did a couple of days, and where was that?
Baltimore.
And how much did you net for the entire weekend?
15,000.
Okay. And are there expenses associated with comedy clubs?
Yes, I have to pay the openers, and I have to pay what they call housing checks and what they call say the club gives you a certain amount of money to get there, you have to reimburse that. So that's $2,500.
And you would agree that May 26th was after April 21st, right?
Yes.
So on April 21st, is your income of April 21st accurate that you hadn't earned any money?
Yes.
Do you have a bank account?
Yes.
And where's that bank account?
Navy Federal.
What is the balance in that bank account?
Right now, probably about $99.
Okay. How do you pay your bills?
I don't have any bills. That's the whole case.
You don't have rent?
No.
Do you own your 1999 vehicle?
Yes, I do.
Okay. And who pays your rent?
There's no rent.
Where do you live?
Rodriguez has a casita that I've been staying at since I left Atlanta. So
How long have you been there? Living with him for
I'm
free?
sorry, Judge, I didn't understand any of that.
Rodriguez.
Robert,
Rodriguez has a casita that you've been living at since you left. I didn't hear the last part.
Atlanta.
Since you
when
left
did you
Atlanta.
leave Atlanta?
Man, what month is this? So it had to be, not May. April?
April of this year?
Yes.
Okay. And who did you live in Atlanta with?
No one.
Yes. And, Mr. Love, do you have any savings accounts anywhere?
No.
Do you own, other than your 99, other than the vehicle we spoke about, do you own any boats?
No.
You own any not motorcycles, do you own any jets?
No.
Do you own anything of value? Other than your vehicles?
No.
Do you have gun collection?
No.
Okay. Do you have arcade games?
No.
Have you ever lived out of your vehicle?
Yes.
For how long did you live out of your vehicle?
A month.
Okay. Was that recently?
Yes.
Okay. Have you given cash to Miss Love over the years?
No, that's not Miss
Miss
Love.
Lee, I'm sorry.
Yes.
Okay. Did you pay your attorney's fees, or did friends of yours pay your
Friends
attorney's
of
fees?
mine did.
Did you pay any of the money to any of your attorneys?
No. All friends did.
And do you pay rent to Mr. Rodriguez?
No.
Do you reimburse him for the food he buys?
No.
Is Mr. Rodriguez your friend?
He's like my brother.
You were held in criminal contempt court for very colorful language. Do you regret those actions?
Yes.
What was going on in your life at that point in time?
Well, to be honest with you, you have been the best attorney I have.
Okay, I understand that. Thank you for the compliment.
No, I'm just gonna have to say it. And make everything clear. I've been dealing with this guy for 7 years and his made up stories. And what the judge was hearing was me be frustrated, and I'm sorry about that, because I get tired of the lies. I get tired of him lying and him making me stop working. The reason why I can't work is because he sends these letters out and says send him 55% of the money. And people are like, what are you talking about? So, Your Honor, what you were hearing was a frustrated black man saying, what is this? I've always taken care of my daughter.
You see your daughter too, right?
Yes, I had just saw her. This lady had dropped her off and gave her money because she just had a new daughter and she didn't have no.
Let's not just keep to this. I don't want you to get upset because you are an excitable gentleman, right?
Yes, but
Okay.
Your Honor, that's what you were hearing was 7 years of fighting. My daughter was born during COVID. Nobody made money during the coronavirus. She was born in the middle of it. She flew to see me in Vegas with my daughter for the first time. Did you see me working? I wasn't working for 4 years.
I want to stop you there. Do you believe, moving on, because there's going to be hearings, that you can control your behavior with your new attorney?
Yes, but Judge Tilley was one of the best judges ever, and he understood exactly. And I didn't give you a chance to.
Do you believe your case was presented by your previous attorney to this court?
No, that's what I said. You were one of the
Do
best.
you believe your voice was heard?
No, my voice was not. That's why I'm at ease now, because you got somebody to match the liar.
Okay, well, let's not do that. I understand, and we'll take care of that at future hearings. But Mr. Love, do you have the current ability at this point in time to pay $2,500 a month in child support?
Right now?
Yeah.
No.
Okay. Tell us about the movie that you lost to you're being incarcerated.
It was a movie.
I'm just gonna object as to relevance of,
Well, it goes to the sentence,
His
Judge.
testimony?
The sentence is preventing him from working and ruining his name in Hollywood. So if he's in jail, he can't work. He just lost a movie, which would have given Miss Lee money because this gentleman would
Right.
have.
I get the overall the objection.
Did you lose a movie due to being incarcerated?
Yes.
Are you possibly going to lose future deals, in your opinion, by being incarcerated?
Oh, yes.
Okay. Are you aware that your name is all over the news?
I just found out now. Oh,
All over. All right, and Mr. Love, the missed court date. Did your attorney at any time call you in the months leading up to that court date to advise you had to be there?
no.
Did your attorney call you the weeks before?
Judge, I'm just gonna object, and if he is opening the door to this attorney-client communications, I just want it known that that opens the door to me to ask questions of her, that I can depose her, that there will be a waiver of attorney-client privilege,
That
and
is
that we can
incorrect.
determine whether this testimony is accurate or not.
That is incorrect. It would be limited to what I'm asking him. I'm not asking about attorney-client communications. I'm asking whether he was notified.
Well, but
That doesn't open the
communications,
door to everything.
well, agreed, but communications from the attorney to him about appearing at the hearing,
Okay. I'm not
whether, when it is, should he appear,
I'm
attorney's
not
not.
asking what his attorney told him. I'm asking that it did not occur. Let me rephrase it. At any time, did you receive notification from anybody at your attorney's office that you needed to be at that hearing?
That day before. The night
Still opens
before.
the door, Judge.
That's
The day before. And which hearing are we talking about? The one that
one
he
that you held him
missed
in contempt for missing.
on April 8th. There was one April 8th, and then the follow-up was April 21st when he was on Zoom.
So he was on Zoom then, but his own attorney didn't show up on April 8th for the record.
Yeah, nobody showed up.
Right.
So what's Mr. Lansky, your question is to him,
My question is, was it willful?
okay, did he receive any communication from anybody at his attorney's office that he needed to appear at the April 8th hearing that he missed? And what's your answer to that, sir?
No.
Okay.
And that's all. I didn't ask him what the attorney
All right, because
told him.
he just said, well, not until the night before, so it sounds like I
Well,
wasn't.
if you recall, Judge, she was telling me not to answer your questions.
All right, I think we're talking about the two different hearings. There was one that you missed that nobody was at.
Right.
Did you get notification from your attorney with respect to
No,
that?
I didn't get into the night before, the one where
You did appear.
right.
Okay.
So the one on April 8th, you did not receive notification. You did not receive notification from anybody.
No.
Okay. Had you received notification, would you have shown up at that hearing?
Yeah.
Had you ever missed a hearing in any case, in any of these cases, any of the proceedings since 2023?
Yes, one.
And what was that?
I was in South Africa, and when he went to overturn what Judge Tibble did.
The attorney's fees?
Yes.
Okay. So you missed that hearing. Do you know if your attendance was required at that?
I didn't even know because he sends thousands of emails out every
Were you
day.
represented by counsel at that time? If you remember.
I think I was.
I'm just gonna check the relevance.
Yeah, I mean, a pattern, I mean,
All right.
I'll sustain on that.
I think I've demonstrated the
All right.
April 8th is the only thing relevant here, Judge. I was just trying
Right.
to show that he didn't intentionally miss any other hearings except for evidently one that I don't know if his appearance was even required at when he was in South Africa. So I don't have that information. Mr. Love, do you regret your actions of that day?
I'm not appearing? Or-
No.
Oh, of course. I mean,
Judge,
not
okay.
hearing it now, like I said, I appreciate it. I appreciate the second chance. I didn't. What you were hearing is a frustrated man, because
Don't make comments about his
Okay.
ability as an attorney or his.
I'm just gonna object to leading and coaching.
All
I'm
right.
saying, answer my questions only, don't make
Right.
comments about
The
this
question was, do you
attorney.
regret your actions on that,
No further
on
questions.
April 21st?
yes.
No further questions.
Okay. All right, Mr. Rothbard, any questions?
Yes, sir. Mr. Love, you said that the only bank account that you have is at Navy Federal.
You can answer questions.
Yes.
Is that true?
Yes.
Have you ever had more than $50,000 in the past 12 months?
No.
At the hearing, which took place before the general magistrate on September 11, 2015, you were present, correct?
2015?
I'm sorry, 2025. You were present, correct?
I don't. You have so many hearings.
The hearing in front of the magistrate on April 8th, 2025?
No, the hearing in front of the general magistrate, September 11th, 2025.
I think, Rose and the other attorney was there, I wasn't there.
Judge, I'm asking the court to take judicial notice of the hearing officer's findings of fact, conclusions of law, and recommended order, which was entered by you on December 5th, 2025.
Yeah.
How was it entered on on what date?
December 5th,
There's a-
2025.
He just said that there was a hearing on 9/11/25, and then that you signed an order on that hearing 6 days earlier before.
The hearing was on September 11th. The order was on December 5th.
Oh, December. I thought he said September.
Right. In that order,
4 months later.
the magistrate made findings holding him in contempt.
Okay.
I did an order confirming that, adopting that report and recommendation, and the findings at that hearing, within that order, that he was not present at the September 11th hearing.
Okay, so he wasn't present.
Correct. I mean, I'm going to take judicial notice of that. It's in the file. I've reviewed that order. So.
Right. I'm just saying, he said, were you present? So he wasn't present. You just confirmed.
Correct.
Thank you.
According to the order, it was not. Yeah, it was a hearing in front of the magistrate that her order says he was not
So
present.
then I'd object to him
Right,
referring
respondent
to
Faizon
testimony
Love
he
failed
knows
to appear
anything about
despite
that
proper
hearing.
legal notice.
Both y'all were talking at the same time. So
I object to him questioning him about a hearing he wasn't present at about what was said. He wasn't there.
well, I don't know what the question. I think the question was, were you there? And he said no. So, what's your next question?
Okay, that's fine.
Were you aware that your lawyer on your behalf represented to the court that you had $100,000 that you could make a child support payment for on October 1st of 2025?
Was I aware?
Yes, sir.
No.
I'm sorry, what?
No.
So it's your position that your attorney didn't get this information from you and she
Objection calls
just
for speculation.
made up that information?
Objection calls for speculation of what his attorney knew or didn't know. His attorney's
This
not.
is the same thing that he was asking, well, my lawyer didn't tell me this, but his lawyer came into court and said, yes, Judge, my client can make a payment of $100,000.
Right. So, I mean, I think you can ask about that representation that his attorney made to the judge, to the magistrate judge.
Well, I understand that, Judge, but an attorney's testimony is not evidence, shouldn't have been considered as evidence, because she's not a party to the suit and she can't testify. Okay, so I don't know how an order was entered. It's finding that as fact when an attorney represents something, because that's not evidence. My opening statement is not evidence. My closing statement is not evidence. What I say is not evidence, and what an attorney said is not evidence, and should not have been relied on by the general master or by this court in entering an order. It's not evidence.
All right. That's a separate argument from the objection to the question. The question was, why don't you repeat your question? I was asking kind of what was your attorney thinking, but why don't you ask a different question?
So you don't know why your attorney represented to the court that you had the ability to make a $100,000 payment by October 1st of 2025?
Objection calls for speculation of what his attorney thought.
I'll overrule.
If you know the answer, you can answer.
I'm sorry, what did you say?
Oh, no.
You have no idea why your attorney would say that?
Objection calls for speculation of why his attorney said something, Judge. I mean, how can he answer why his attorney said something? Obviously, he's already said he wasn't very happy with that attorney,
It's overruled. He can answer the question.
if he knows.
Yeah.
No.
What?
No.
And you at no point told your lawyer that you could make a payment of $100,000 by
Objection
October 1st?
calls for attorney-client privilege. What he told his attorney is privileged.
He's saying he didn't tell his attorney that.
He's asking if he told his attorney something, whether he did or not. He's already answered that question. Now he's asking for what was
He's
said
coming
to
into
his
court and
attorney.
saying, my attorney represented something in court, but I didn't tell her that. And I'm now saying,
That's what he
no
answered,
point
Judge.
did you tell her that to
I-
confirm that, because at
I
this point,
don't think he's actually, I don't know if he's answered the question. I did not tell her that. So the question of, did you tell your attorney that,
Can I say it now?
is, I'll give you a warning, Mr. Love. Your conversations with your attorney generally are privileged. You're the one that controls that privilege. You have the right to waive that privilege. I'm not forcing you to waive the privilege. The question, though, was, your attorney made a representation in court, and did you tell your attorney to make that representation? Is the question right now.
Judge, I'm asserting his attorney, I'm making an objection, that's attorney-client privilege. If he says yes, he's violated attorney-client privilege, that's asking for attorney-client privilege. If he says no, he can't, it's a back door. What he told his attorney is privileged, period.
What was your argument, Mr. Rothberg, on that?
He's waived the privilege.
Based on what?
He's making a representation that, I don't know why my lawyer would say that, he's not saying I never actually said that to my attorney, but he's saying I have no idea why she would say that. And the
that's
question was,
his answer.
did you tell her that? Because if he's making representations that he doesn't have this money, that he's never had this money, but yet it's in a court order by his own lawyer at the time saying, I can make that. There was never any motion for rehearing, there was never any motion for reconsideration, there was never nothing to dispute that other than just a non-payment for which a contempt is currently pending. And Mr. Love is saying, I don't earn any money, I haven't earned any money, I don't have any income, I don't have any bank accounts, but yet he has his lawyer coming into court and saying, I can make a payment, my client can make a payment of $100,000 by October 1st. I really doubt that an attorney would make that representation without approval from his client. And he's waiving the privilege by saying, I don't know why she would say that. And I'm asking, did you tell her that? And if he's going to say no, we have the right to go to his attorney, subpoena her, depose her, and say, Miss Selly, Mr. Love is saying that you said that he never told you and never gave you authorization to make this representation about this $100,000 you have. Is what he's saying the truth or not? And Miss Selly would be in a position to say,
No.
yes, that's true, I just made up that story. Or Miss Selly's in a position to say, no, Mr. Love told me that. He
No,
said
she couldn't say that, Judge. She couldn't say that unless she wants to be disbarred.
And this his credibility, Judge. He's coming in here making all these representations to the court after we know he's made misrepresentations to the court in the past. You can take judicial notice of the final judgment in this matter, of the GM's reports in this matter.
I've reviewed the report. Mr. Lansky, it's your position that the attorney can make a representation in court that your client can disclaim and say, I have no idea why that happened.
I have no idea why she made that representation, Judge. She's not here.
And no one is
she wouldn't
permitted.
be able to testify to that.
What's that?
You cannot force her to testify, and she would have
So
problems with the bar.
no one can testify as to that?
He said he didn't have $100,000. That should be sufficient, Judge. Anything that he said or didn't say to his attorney is privileged, and you cannot break that privilege.
Despite allowing his attorney making a representation.
I have no idea. You'd have to ask his attorney that.
But
He's already testified.
I know, but then you just testified she can't answer that question.
You're right, Judge.
So no one can answer that
No,
question.
the question is, did you have $100,000 in a bank account? The answer was no. That should be sufficient for this court, and that's the only thing he can answer, and that's the only thing I'm going to allow him to answer.
I think he has waived the privilege of, did you authorize your attorney to make that representation to the court? I'm going to overrule
Who's
it.
waived his privilege?
I'm finding that was a waiver of privilege. He needs to answer that question.
Wait, we're going to have to get this straight for the record. You're saying what?
He's
You're
waived-
requiring him to testify to what he told his attorney. That's what you're requiring.
I think
for the record.
when his attorney makes a representation to the court, then he later says, I have no idea why that was made.
Why isn't that a proper answer? I have no idea why that was made. Why should he have to say what he did or didn't say to his attorney, which is clearly attorney-client? There's no exception to privilege here. He hasn't opened the door. He hasn't waived any privilege. I don't think you can force him to testify to anything he said to his attorney under any legal authority. The attorney, if they want to call the attorney and she wants to break privilege, I'll have my actions against her. She's not here to defend.
Well, she can't break privilege. It's his to waive.
But he's not waiving it.
Well,
So
he asked. I was explaining about his right to waive it.
Okay.
You've made that objection. It's not yours to waive. It's his to waive if he wants to
Let's
waive.
ask him, do you waive your attorney-client privilege? Do you waive your client? Do you want this court to be able to force you to testify to what you told your attorney?
To leading
Yes or no?
No.
and coaching, again.
I asked him the question, do you waive your attorney-client
Yeah,
privilege?
I understand. I heard you.
But the court can find there's a waiver. And I think the court did find there was a waiver.
Yeah. Did you, I'm finding there's a waiver just with respect to that question. Did you authorize your attorney to make that representation of $100,000? You could pay $100,000.
Are you asking me?
Yes, sir.
No.
I'm over my.
Over your objection, correct. Sorry?
Reserved for appeal.
Sorry?
No.
No, okay. All right, I'm not going to allow any other follow-up questions on that.
Thank you, Your Honor.
Very well, Judge. Let me just take my notes so I can follow up on this and put it in an order.
And I'm sorry for interrupting, Judge, I'm just trying to make the record clear.
I get it.
Okay, did you ever provide the bank statements from Navy Federal in the last year?
I can answer.
Yeah, answer yes.
I put it in the first financial order, whatever the affidavit was.
You put the words Navy Federal in your financial affidavit?
Well, on your financial affidavit, it asks to list the 4 last numbers of the bank account.
And did you do that on the financial affidavit you filed on April 21st?
Yes.
And did you put the name of the bank, Navy Federal? Mr. Love?
Your Honor, I think I answered the question already.
I think one question was, did you put the 4 numbers of the account? You said yes. Did you put the name Navy Federal Credit Union on the affidavit?
Affidavit asked me to put the last numbers, 4 numbers.
So just yes or no?
No.
No, you did. I'm sorry, Judge, I want the record to be clear. Did you put the name of the bank, Navy Federal, on the financial affidavit?
No.
I think you didn't, but you did put the last 4 of the account.
Yes.
Can you make a screen share?
Yeah, go ahead. And
Okay. It says I sent the request.
I don't know if he'll be able to see it. The monitor's fairly far from him, but
Okay.
do you have a copy of his financial affidavit?
I don't know which one.
The one that was filed April 21st.
Yeah, I do, Judge.
You want to show that to your client?
What am I showing him? Which page?
Well, whatever page Mr. Rothbart's directing you to.
What page is he directing me to?
Well, first I'm going to ask him if that's his financial affidavit and if that's his signature on it on page 17 of 19, which is number 14 of 15.
Yep.
Okay. And you recognize this document?
I've seen it before, yes.
Okay, and you signed it?
Yeah.
And when you signed it, you stated under penalties of perjury, I declare that I read this document and the facts stated in it are true?
Yep.
Okay. Now, I'm going to take you to the section regarding your assets, which is on the bottom of page 8 of 19.
Judge, I'm going to object to, we're not here, we're on a motion for rehearing. He's testified, but if we're going, this is not a hearing to determine the accuracy of the financial affidavit. You held him in contempt, saying it was inaccurate without being.
Judge, I'm just going to ask him if the bank account, the last 4.
I think it's just to impeach based on his answer that he just gave.
Okay. Well, we'll
So-
stipulate the bank account digits are not in here.
The digits are not on there. All right, so they're not on the financial affidavit.
That is correct.
All right.
They're not
And,
in here. It's not in here.
You have a cell phone?
Yes.
And what company is that cell phone through?
T-Mobile,
Okay. And who pays that bill?
Robert, it's under his company name.
What's the company name?
Robert Rodriguez, Holdings.
And it's your position that if T-Mobile were to be subpoenaed, that it would show all your payments for the last 6 months to be paid by Mr. Rodriguez and/or Rodriguez Holdings.
Objection calls for speculation of what T-Mobile's records would show. He has no idea what T-Mobile, how they keep records, whether they keep records of payments or is
Right.
it all
I mean,
ACH.
yeah, I'll sustain.
Judge, he just testified that Mr. Rodriguez paid all his bills, and now he's saying, oh, I don't know what T-Mobile's records are going to show.
Well, how would he know
He
what
didn't,
T-records?
he didn't give an answer. I sustained an objection on that question, so you can ask another question.
Okay. But it's your position that the payments weren't made by Mr. Love or by some company owned by Mr. Love, correct?
Who's he asking, the attorney?
You're asking Mr. Love that question?
Yes.
All right, let's not refer to him in the third person, so
Sure.
ask another question, or ask that question again.
Mr. Love, it's your position that any records from T-Mobile would show that the payments were made by you or one of your companies and not by Mr. Rodriguez or one of his companies, correct?
Same objection, he doesn't know what T-Mobile's records.
Yeah, I mean,
show. He
yeah,
testified
what the
by-
records may or may not show. He testified as to how he has T-Mobile and who pays it, so I think that's what we'll leave it at. I'm gonna sustain the objection on that.
Okay. The comedy club in Baltimore that you got paid $15,000 from, when was that?
What month is this?
He already testified, May 26th, 25th, 26th timeframe.
Yes.
May 26, 2026? And you said you got $15,000. What bank account did that money go into?
It went to the promoter that booked it, Eric Young.
I'm sorry, the what?
The promoter that booked it.
Eric Young, he said.
The promoter, Eric Young?
Yes.
So the money went into his bank account.
Yeah.
And why did it go into his bank account as opposed to your Navy Federal
Because
bank
that's how
account?
we do business.
Can you expound upon that,
No.
Judge?
What's the question? That's how they do business, what, can you, he's,
Yeah, ask a better question than just expound on that.
Why did you put the money into Eric Young's bank account as opposed to your bank account?
Because he's a facilitator of the gig. The money goes to him first, then he distributes it.
distributes.
Yes.
And when he distributed the money to you, where did that money go?
I haven't got mine. I was in jail.
And you also got paid from the Comedy Loft in DC, correct? You have a show there in 2025?
No, I did not.
Give me just a moment, Judge. Do you recall a hearing with the general magistrate on September 11th of 2025 wherein we addressed the matter of your payment from Comedy Loft?
Your Honor, it's already been established he wasn't present at that hearing.
Yeah, I mean, he wasn't there, so I'm not really sure how he can recall that.
Sure. Did you hire an attorney in Washington, D.C. to dispute the payment from D.C. Comedy Loft?
I didn't hire him. He wasn't, he was just upset at the whole motion, how it all went down, and a friend of a friend, and he just kind of took reins. Talking about Ryan, he kind of took reins because he was
Ryan
really
Jones.
upset. Say again?
Ryan Jones.
Yes. He kind of was upset because when we went to go settle out, do I need to tell this?
Yeah.
We went to go settle out, and they said, no, this money is being garnished by you. And he was one of the people there that were there from Trump's office, and a bunch of people from DC was there. Yeah, and it was pissed off, excuse me, Your Honor, that they would do this without telling me that you had sent the letter there. So I did the shows and promoted it, and then when it was time to go through the numbers and everything, he says, no, we can't give you this money because Roadworks, whatever your name is garnishing the money and we gotta hold it. And Ryan was there in the green room when that happened, and he got really upset. He was like, you got really upset. I didn't even know him. He was just part of some friends that were there from the White House.
So Mr. Jones worked on your behalf to try to prevent the garnishment of these monies from the DC comedy law,
No,
correct?
that's not wrong. He wanted to know what happened. Like why is he called it I forgot.
Obviously, Judge, this is hearsay, but
Right.
But it's in the court order.
He called it a legal
Over.
Oh, sorry.
Go ahead.
I don't mind him answering. I'm just saying it is all hearsay. But it's in the court order. Why can't we take judicial notice of the court order?
He found it illegal that you would say how you worded it, and you made it seem like it was an order from the judge to pay you 55% of whatever I made directed to your account.
So you're saying there never was such an order?
No. To pay you some money?
Yeah, to make payment to
No,
me
no,
on
no.
behalf of
To pay
my
you some
attorney,
money.
is that misleading?
To pay you 55% of my money. That's what he was mad. Like, not in order to pay child support, to pay you. That's what it says. Pay you 55%.
So the order that I sent to the DC comedy law, on your behalf, he disputed the payment pursuant to that order, correct?
Now I would say calls for speculation. I mean, we've gone through the hearsay.
And we're getting a little far afield of what we're here on here today. So
Sure.
that's in the magistrate's order. We're not really litigating that right now.
Sure. So the money from DC Comedy Loft, when was this whole thing with the DC Comedy Loft, with the green room and him being there? Was that in 2025?
I don't even know. What do you mean?
All these things that you just testified to, that you were at the green room with Trump and Mr.
I didn't say he was in
Jones.
the green room with Trump. I said friends from Trump's office came to see me, and he was part of that crew.
Okay. And when was this?
That the time when did you get it? When did you send the
I'm
letter?
asking you. I wasn't there
When
when you were in
did
the
you
green
send the
room.
letter?
Do you recall the date?
I do not. It was in April or something like that.
Of what year?
1666.
Really?
What year, Mr. Love?
If you recall the date.
It was 2 years ago, I think. 25 or 24. It was about 2 years ago, I think.
Well, the hearing was in late 2025, so this was actually in April or so of 2025, correct?
So if you knew that,
Judge Aston answered. He obviously had the document in front of him, and he said he didn't remember.
All right.
Said 24,
I think
25.
sounds like April 25 sound correct, Mr. Love?
yes, sir.
All right.
Where did that money go that you received from that show? What bank account?
I didn't get it. You
Well,
got
you
it.
did. You got half of it. You got 45%.
No, I did not.
Okay. So where did that 45% go?
You got it.
So this is my question very carefully. The order garnished 55% of the income.
Where did that
That
come from?
means there's 45% which wasn't garnished.
Can I ask you a question?
Just
Where did that money
wait.
go?
I'm gonna object. I mean, I think we're way outside the scope of what we're here for today, because now we're getting into, again, this is not set to determine the accuracy of the financial affidavit. It's not here to determine the accuracy of anything. We're here on my motion for rehearing and the legal basis I've stated for both the criminal and civil contempt, and to ask that the sentences be modified, and also not the semantics, the logistics that I've already said about how it was done, the criminal contempt.
Yeah, I've let it go a little. I've let it go a little bit beyond what I think the issues are for this hearing. Because it is the veracity of the financial affidavit is somewhat relevant to the indirect civil contempt. So I think we're getting a little bit too in the weeds here on this, Mr. Robert. Though.
Sure, I just want to clarify that he's saying, oh, this one bank account that never had any money in it is my only bank account, but yet he got a $10,000 payment or so in April April of last year that he's claiming, well, but I don't want to tell you where that money went.
That's not
Because
what
Right, I think he's
Judge.
testified about a bank account. Anytime you get paid from any comedy show, does that money ultimately, when it gets transferred to you, is it into your Navy Federal Credit Union account?
It was, but then it got garnished.
There's I'm asking about the ungarnished portion.
What do you mean
55% was
ungarnished
garnished by the
portion?
court's order.
What do you mean the ungarnished?
Bank account, first of all, can be garnished for anything in the bank account. We all know that as
The
lawyers.
bank account wasn't garnished, it's the payment that was garnished, Judge.
No, the bank account
See,
was.
it's
I mean, I've reviewed some of the file. I think there's a previous order that freezes accounts and basically all assets. So,
And it's also got another $500,000 judgment that garnishes his bank accounts. Judge, his testimony is, but in doing that and getting the documentation for you to suspend the rest of the sentence, not or commute it. But the bottom line, Judge, is this is not a hearing to challenge the veracity, just like the last one wasn't, whether it was complete or not. The last hearing was set for a specific order to show cause, and you started to do inquiry, but that wasn't noticed.
I get it. You
Okay,
made that
so
argument.
that's the-
We're in the middle of the. Any other questions, Mr. Rothbard, you want to ask Mr. Love? I'm going to sustain the objection that regarding the garnishment. I think we're getting too far into the weed. This is really beyond what this hearing's noticed for. So, any other questions, Mr. Rothbard, on that issue? On basically what he testified to on direct?
No, Judge.
Okay.
I'm not gonna, I've already made my arguments, Judge, I think
Right.
you've heard them, I'm not gonna
Right. Any
closing or anything like
kind
that.
of closing argument, Mr. Rothbard, you want to make?
Judge, my client wants to say something?
All right, you want to call your client. Ms. Lee, if you could unmute your line and raise your right hand. Do you swear
Did you
or...
want to testify or you wanted to talk to me?
I just wanted to make a statement regarding,
Hold on.
Let me put you under oath.
Raise your hand and let it put you under oath.
Do you swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you.
Ms. Lee, you heard Mr. Love's testimony. Is there anything you wanted to comment on that?
Yes, this is actually pertaining to the April 8th hearing, and his claims that he was unaware that there was a hearing. I personally informed him of the hearing. I called him on April the 7th, which was the night before, and the reason why I took the initiative to do so, because he had missed the previous hearing and he kind of blamed me for it because I was aware of it and did not inform him when we do speak on a regular basis. So I told him from now on, if there's a hearing, I will let him know personally. So I did call him on April the 7th at 7:01 p.m. He did not answer. He returned the call at 7:24 p.m. And I did not answer. And then I called him back at 7:24 p.m. And he called back via FaceTime. I informed him of the court hearing. And he got, he asked me what it was for. I told him I was unaware, but I gave him the time. And he specifically told me that he was not going to show up to the hearing because he was tired of going to court and he just wasn't going to show up and play NIGGER games. So then, after the hearing took place around 3:30 p.m., he got angry at me and he said
Judge, I object to relevance. She's already testified about the hearing, what she says happened, but anything that happened afterwards isn't relevant to this purview.
Well, I have text messages to prove the claims.
I know, but with respect to missing the hearing or...
With respect to missing the hearing, yes. He was well aware that there was a hearing, and he informed me that he was not going to show up because he was tired of going to court.
She's already
Right.
And then
testified
he
to
also
that.
texted me saying, I'm not going to go to court for this on the day of the hearing.
Okay. Okay.
And that's obviously different than what he testified to, correct? That he
That
didn't
is-
know about the hearing?
That is correct, yes.
Are you a citizen?
Stop. Don't just stop.
All right.
Immigration.
Any other
Okay,
questions?
what did he say, Judge?
No, he's not saying anything. He's not.
Any other
Your
questions?
Honor, in
Did
the
he say
very,
something?
oh, I'm sorry.
Well, he's not the attorney, and he's not under oath, so he's not saying anything.
Okay.
And
In
Judge,
that
as
very
she's testing in
same
the narrative,
Mr.
are there
Rothbard,
questions?
Mr. Rothbard, any other questions you have for your client?
Yes, was there anything else that Mr. Love stated in reference to him missing the court hearing?
Yes, he referenced that he was angry and that he was, that he could have ICE raid my home, for, continuously taking him to court, but that was about it.
Nothing further, Judge.
All right,
Nice caller.
any other questions, Mr. Lansky, for, all
Miss
right,
Yeah, just one question for her.
Ms. Lee?
Miss Lee, do you understand if he's in jail he can't work?
I do understand, yes.
And how does that help your child?
Objection, relevance.
Very relevant.
Overruled.
How does that help your child if he's in jail and can't work? How does that benefit your child?
Pardon?
How does that benefit your child if he's out of work, can't see her, and can't work? How does that benefit your child and her best interest?
Objection, argumentative, relevance.
Very relevant.
Overruled.
Ma'am,
Yes.
can you answer my question? How does that benefit your child if he's in jail and can't work a movie that he just had a contract for? How does that benefit your child in child support?
Objection, compound argument.
All right, overruled, just, we need to answer the question. You keep rephrasing different questions, we get different objections.
trying.
Answer the question, I overruled it, have her answer that same question.
Go
Go ahead, Ms. Lee.
Well, I don't think it affects her at this very moment since he's not making payments and he's been avoiding payment, and he specifically told me that I wasn't going to get a dime, and that he was going to stop working and canceling shows. So I won't get anything, so I don't think it personally affects her in the moment. It's not as if he was, providing before, and then with him being incarcerated, he's suddenly not able to provide.
Well, how much money?
She's not feeling it at this very
How much
time.
money have you received from the garnishments? In addition to the $43,000 since 2022, how much money have you received from the garnishments Mr. Rovart's gotten for you?
Objection, relevance.
That's not really relevant.
All right,
Okay.
move
So
on.
sustained on that.
All right, same arguments, Judge.
All right, any other, no questions for her? All right, Mr. Rothbard, any kind of closing argument on that?
Yes, Judge. Judge, in addition to what I previously mentioned earlier, we absolutely have some credibility issues on behalf of Mr. Love. He's made various statements like, I didn't know about the hearing, when we clearly have evidence that he did know about it. Separate and apart from his lawyer, he was told about it by Ms. Lee. We also have credibility issues about his banking and his payments. Oh, well, the money went to this other person and I never got it. And at this other show, yes, I hired this lawyer that was a friend of mine and he disputed it, but I don't want to say where the money went.
Judge, I'm going to object that he's mischaracterizing the evidence and the testimony.
Hold on, there's an objection on mischaracterization.
Mischaracterizing the testimony.
Overruled,
I'm
it's
going to hope that the court...
it's argument, the court has the independent recollection of the testimony.
Thank you, Judge.
Regarding the $100,000 representation, well, I never told my lawyer that, but I'm claiming privilege where I don't want you to ask my lawyer if that's actually true or not. So separate and apart, in addition to all the other things I mentioned earlier about everything, his credibility is zero, is less than zero, Judge, and you should disregard it. Regarding his direct civil contempt, it is punitive, and as you heard his behavior today, while he didn't obviously go off as far as he did last time, he still, made inappropriate comments. I didn't hear exactly what was said because his lawyers didn't
I'm going to
understand,
object.
but I
First
heard
of
it,
all,
and I'm sure the court heard it.
I'm going to object, okay? He did not cuss at anybody. He answered the questions. And for him to
All right,
state
what's
that
your
it's
objection?
inappropriate-
I mean, it's
He's
overruled. The court
totally
had,
mischaracterizing the evidence.
I've heard what's happened here today, so overruled. The court will consider it.
Purposely.
He also made statements that were clearly lies and inappropriate, like what year did you do the DC Comedy Law? 1666. Well, I think the court can take judicial notice of the fact that that's impossible, and that he was just being rude and sarcastic and disrespectful to the court, which is exactly what he got held in contempt of court for. The direct contempt is appropriate. His behavior was not just a one-time thing. It was out of control. It was repeated. It was over and over again. It was after numerous warnings, and he's still doing it today. He's still making inappropriate comments in court, to the court, obstructing the proceedings of the court. Regarding the indirect civil contempt, Judge, he still hasn't provided the documentation. He still hasn't provided all of it. He said, I provided the name of the bank, and I provided I provided the last four, but it wasn't there. Even his lawyer once stipulated it wasn't there. He still hasn't provided his actual bank accounts, the documentation. He's saying, I don't know where all this money went. no documentation of any of his expenses that are paid by anyone else. And all that documentation would have been contained in his discovery that was requested, which he still hasn't complied with. I think the motion for rehearing should be denied, Judge. I think if anything, Mr. Love's behavior, not only in court, but by disregarding the orders of the court and failing to turn himself in, failing to make that payment pursuant to the prior court order, failing to make the child support payments pursuant to the final judgment hearing, he just continues to tell the court, I don't care what you're going to say, I don't care what you're going to do, I'm just going to keep going. This is the first time he's getting any consequences for anything in this case. And those consequences should be held. The court should let him know that, Mr. Love, if you're not going to comply with court orders, if you're not going to comport yourself properly in court, you're going to have consequences. And maybe the next time that he's asked for discovery and has to behave himself in court and has to answer questions, he's not going to, give documents that are useless and say, oh, it was in 1666 and completely disregard everything. He owes several $100,000s in child support. His own lawyer said, we can make this payment, and it was never made. And now we say, well, I never even told her that. But believe me, I'm going to depose her. And believe me, she's going to be asked about this. And believe me, it's going to be brought to the court's attention again for more direct contempt. But here we are, and I think the court needs to stick by its order. And, as my client said, he's not making any payments, Judge, so there's no benefit to him being released so he can do some movie that he claims he's not going to do anyway.
Okay.
Judge, I'm just going to ask the court rely, not what Mr. Robarts just testified, because according to my notes, 90% of what he just said was not testified to or done, except for the 1666 thing.
All right.
And I don't appreciate that kind of closing statement, Judge, and I will stand by the purge has to be something he can do. If he's in jail, he can't get me documents. He can't do anything. I am on this case now. He did behave himself today, and I have control of my client. And let's move this forward and get to the nuts and bolts of this, because there's a supplemental petition coming. This 2,500 is going to go down to about 200. Okay, Judge? And the contempt won't even be able to be heard once I file that supplemental petition based on Florida law.
All right. I'm going to take
One
it.
thing I wanted to just add is that
No, he
he
had his
can
closing
absolutely give his lawyer his password to his Navy Federal and any other bank accounts that he may have. His lawyer can go in there while he's in jail, print out PDFs of each and every statement, and contact his accountant and say, hey, I represent
Doesn't
Mr.
have an
Love.
accountant.
I get it. I understand. You've had your argument. Both sides had. I'm going to take a short break. I'll be back in just a few minutes and make a ruling.
Thank you,
All
Judge.
right, thanks. We're in recess.
Enough time to use a bathroom?
There is, yeah. All right, back on the record here. So, first, with respect to the two motions for rehearing on the direct criminal contempt order, the court is ultimately going to deny the motion for rehearing, but will just continue to make the finding that Mr. Love's behavior on the April 21st hearing on Zoom, at which that kind of prompted this. Obviously, he had conduct as described in the order of contempt that was in the front of the integrity of the court and obstructed the administration of justice, prevented the court from even having an inquiry about the financial affidavit. The court certainly recognizes that Mr. Love was emotional in a charged situation in litigation that's been going on for years. That certainly does not excuse the behavior or conduct that he exhibited on that date. But Mr. Love's appearance here today and his demeanor towards the court was more respectful and apologized. And the court also recognizes that he has been in custody for 16 days, having been picked up on the writ in California about 16 days ago. And so given the totality of the circumstances, I'm going to deny the rehearing, but use the court's discretion to modify the sentence and find that his time served of incarceration of 16 days is an appropriate punishment for the contemptuous behavior and conduct that he experienced or that he showed the court on April 21st. Mr. Love, you can see that any future outbursts or such kind of conduct will have consequences and can result in contempt, and you need to show respect to all present, attorneys, witnesses, and the court, and conduct yourself appropriately in any future proceedings. And so, while the court will deny the motion for rehearing, I will modify the sentence to a 16 days credit for 16 on the direct criminal contempt. On the indirect civil contempt, I'm also going to deny the motion for rehearing, leave the finding of indirect civil contempt in place, finding that the failure to appear and the financial affidavit filing, there was still lack of good cause shown on April 21st for those two failures, and the court was that the finding of indirect civil contempt was still appropriate. I'm going to deny the motion for rehearing on that. However, I will suspend the writ to allow Mr. Love to be released to prepare a financial affidavit that is complete and accurate in compliance with family rules of procedure, as well as mandatory disclosures as part of that, and recognize that that's obviously easier done out of custody than in, and the remedy for the indirect civil contempt, the incarceration that has already occurred of 16 days, combined with a temporary, a suspension of the writ, is at this point sufficient to allow him to be released. The purge will still remain to purge that contempt, but I'll let him attempt to purge that contempt out of custody to do a financial affidavit in short order. So July 1st.
What's today?
Today's June 19th.
Okay, so basically 10 days.
So like 10 days, a little over 10 days.
July 1st, is that a weekday?
July 1st is a Wednesday.
Is a Wednesday, so
Right.
July 1st.
So not next week. So I'll order that he is released. You'll be, but July 1st, on or before July 1st, to file a full, complete financial affidavit that Mr. Lansky, you said you've already prepared and is.
I'm just waiting on some
things.
But the mandatory disclosure I'm going to have to get.
Mandatory disclosures are different, so those need to be provided as well.
Can you give me a little bit more time on the mandatory disclosures, just in case it takes? I'll get the financial affidavit filed, but can I get it till
The
like
financial
July?
affidavit needs to be filed on or before July 1st. I'll do till July 10th on the mandatory disclosures.
Thank you, Judge. Just so if we have to order something, we have time to order.
So, Mr. Love, you need to listen to Mr. Lansky.
Yeah.
There's a lot of things that have to be produced.
Yeah.
Tax returns, bank statements, all the things that are part of mandatory disclosures as part of the rule. And you can see what happens when you fail to produce things and otherwise, don't give this the attention that it deserves. So, but you're going to be released later on today. I'm again modifying the sentence on the criminal contempt, finding that the indirect civil contempt writ will be suspended, and you'll be released to attempt to purge that from out of custody. Okay.
Is there a follow-up hearing?
I'm not setting a follow-up hearing. I'll let the parties make a determination as to whether there's compliance with the or whether he's still in compliance with the purge or not.
I just the only thing that concerns me, and I appreciate your order, Judge, and your court indulgence, is if there has to be a determination, if it's been Mr. Robarts may say it's not enough, and I may disagree with him. At that point, we would need the court's determination whether it's been
Correct.
complied with.
Yeah.
I don't want to leave it. It's only up to him whether he thinks it's
No,
complied.
it's not within Mr. Rothbart's discretion. It's still. I mean, obviously the court can make a determination if there's a disagreement about it. It's like regular, a discovery dispute. Obviously, you all communicate as to whether the purge is, there's things that you think are missing. Mr. Rothbart, you've been through this. Both y'all have been through this before as to what you think is missing. And if there's an ultimate impasse on that, then you can bring that up for another hearing. I can bring it back in short order.
Absolutely, Judge.
Okay.
Is the court going to do the order, or does it want me to do it?
Can you prepare a draft on that and then let Mr. Rothbart see it, and
Okay.
we'll go from there.
Did the court reporter take down the ruling portion?
I took down everything.
Okay. Can I order the ruling portion?
Yeah.
From you? Okay. If I get the ruling portion, then I can.
Right.
Then there's no mistake, and I can attach it.
Understood.
That's what I like to do usually. That way, there's no. He or I can't really dispute it if I get the ruling
Right.
portion
You
attached.
can get the transcript. That's fine.
Okay.
Both motions for rehearing denied, but modifying the sentence on direct criminal contempt, suspending the writ released today on the indirect civil and the purge to be done. July 1st for financial affidavit, July 10th for the mandatory disclosures. Any questions, Mr. Rocker?
Yes, sir. May I ask who the court reporter is?
It's a court, we're in a criminal courtroom, so it's a digital court reporter here.
It's a criminal court reporter, okay.
And just, Mr. Robarts, for the record, I'm only ordering from her the criminal portion. I mean, the ruling portion. If you want the whole transcript, you'll have to get it. I'm just saying, I'm only ordering the ruling portion so I can do the order.
No, that's fine.